We will start with a quick video on the return of the bison to Banff National Park to kick things off.
My name is Carson Hoyer. I'm the Bison Reintroduction Project Manager for Banff National Park. My job is to orchestrate all the different moving parts of trying to get bison from Elk Island National Park into Banff National Park. Parks Canada's primary mandate is to ensure what we call ecological integrity, which means the health of the ecosystem. And because something's been missing, North America's largest land mammal, part of our job is to try to bring it back, and that's what this is all about. It's about that effort. From about noon today until hopefully about noon tomorrow, so a 24-hour period, we're actually going to do an operation that has a lot of different moving parts. The first part is actually bringing the animals through the Elk Island corral system and the chute system to give them a tranquilizer, and then do some last-minute changes to ear tagging. And then we'll start to load them in groups of 3 and 4 through the chute system, up the loading ramp, into the containers that we've modified. They're basically sea cans or shipping containers with ventilation in them and a few additions to the doors. And then we'll truck them for 400 kilometers. That'll then take us to the end of the gravel road, Yahatinda Ranch, and then we'll actually bring a helicopter in tomorrow, a heavy lift helicopter that's coming from the coast, and that'll pluck each individual crate off the flatbed trucks. It's one by one over the ridge, about 20 kilometers into the heart of the reintroduction zone, where we have a pasture fenced, where we're going to hold them for the next 16 months, feed them, support them, allow them to calve safely twice, and then do the release after they've anchored to that landscape and have adopted it as their new home. There's been so much research, there's been so much consultation, like literally years. We've got everything in place that we could have possibly thought of, and really from here on in, it's going to be up to the animals. You know, we're talking about giving a species a second chance. The seed that we are planting today, you can't almost imagine what it might lead to in 50 or 100 years.
Over to you, Rob.
All right, thanks, Dave. Good morning. It's very nice to be here. So I'm going to talk about the reintroduction to Banff into reintroduction of buffalo into Banff National Park. Very glad to have Bill here, who's more of an expert on this than I am, but I'm going to sort of take a particular lens to this, a particular angle that I hope will be fruitful and lead to some good discussion as we go on. So the title of the paper that I'm going to talk through is called Buffalo in Banff: Frameworks for Reconciliation in Wildlife Management. So in June 2017, 16 buffalo were transported to Banff National Park, and this is what we saw in the video. So if the reintroduction proceeds as planned, a nascent herd will be roaming largely free of constraint by 2020, over 100 years since the last buffalo were seen in the park. So today I'm going to argue that the reintroduction is one example of Canadian and Indigenous legal systems working together toward the achievement of shared goals. So I argue that the reintroduction of the buffalo to key sites in Canada and the United States, including Banff, represents what I call a framework for reconciliation in buffalo management, in wildlife management. So to do this, I'm going to look briefly at 4 things. So I'll begin by looking at the ways that first Canadian and then Indigenous law are implicated in something like the reintroduction of the buffalo to Banff. Third, I'll look at what I call overlapping law, shared jurisdiction, and reconciliation. Finally, I'll look at some examples of land and resource management that follow the approach that I'm outlining. So to start with Canadian legal perspectives then. So a national park is in many ways full of Canadian state law. So Banff National Park was created under and is managed under authority derived from the Canada National Parks Act. Regulations under the Act govern the identification of wilderness areas, traffic regulations, garbage disposal, wildlife, aircraft, fishing, and on and on and on. There are also extensive regulations governing the town of Banff itself, as well as commercial ski areas. So national parks are highly regulated spaces. And this concentration of state law has historically worked to exclude Indigenous peoples and their laws from those areas. So in respect of the reintroduction of buffalo in Banff, the prevalence of state law meant that the project could not move forward until certain Canadian legal requirements were met. So an environmental impact analysis, for example, had to be carried out. Parks Canada has authority to carry out EIAs on projects on federal lands under Section 67 of the Canadian Environmental Assessment Act. So I recognize that's now likely going to change with the legislation that was introduced a couple of weeks ago. This is how it was given effect at the time. So this required an assessment of whether the project was likely to cause significant adverse environmental effects, and if so, if those effects could be justified. So Parks Canada performed the detailed environmental impact analysis and looked at things such as soil, vegetation, fire, wildlife resources, aquatic resources, cultural resources, species at risk, visitor experience, and the socioeconomic dynamics of surrounding human communities. So in all of this, during the course of this assessment, they determined that the impact would be insignificant. So in the pilot phase of the project then, which runs until 2022, buffalo will be limited to an area designated as a wilderness zone under the Canada National Parks Act. As such, the wilderness character of the area is a priority and it won't be accessible by motorized vehicle. So the reintroduction zone is then further subdivided into 3 bison management zones in accordance with the Bison Excursion Prevention and Response Plan. So until June 2018, the animals will be kept in an enclosed soft pasture release. At that point, they're released into a broader 1,900 square kilometer reintroduction zone. The animals will be monitored closely throughout this period, and if they venture into a peripheral hazing zone, they'll be herded, hazed, or baited back into the reintroduction zone. So at the end of the 5-year period, the project will be evaluated in light of project targets, and a determination will be made as to whether the project should carry on or not. So this is a cursory overview, but I think this suffices to show that the reintroduction of a species into a national park requires considerable movement from Canadian law, from state law, right? It implicates state law in a number of different ways, and there are a number of legal processes that have to be worked through. So those are the some Canadian legal perspectives on a project like this. So looking then to some Indigenous legal perspectives. So in September 2014, 10 Indigenous nations from both sides of the US and Canada border came together in Montana to sign what they call the Buffalo Treaty. So the aim of the treaty is cooperation regarding, and I quote, the restoration of buffalo on reserves or co-managed lands within the US and Canada. And the treaty was the outgrowth of the Illini Initiative, conceived of by leaders of the Blackfoot Confederacy in 2009 to reintroduce buffalo to their nations. 2 years after the treaty signing, 87 plains buffalo were transferred from Elk Island National Park to the Blackfeet Nation in the United States. And since the initial signing, a dozen more First Nations in Canada have signed on to the treaty. So quite a substantial number of First Nations now are parties to this Buffalo Treaty. So the treaty was drafted in recognition of the historical importance of buffalo to Indigenous peoples of the region. So it's an initiative aimed not only at strengthening buffalo populations by reintroducing them into traditional habitats, but at reinvigorating and recovering Indigenous cultural, spiritual, and legal practices associated with the buffalo. So this is reflected in the full name of the treaty, the Buffalo, a treaty of cooperation, renewal, and restoration. It's also reflected in the purpose of the treaty as stated in the text, and that purpose is to honor, recognize, and revitalize the time immemorial relationship we have with buffalo. It is a collective intention of we, the undersigned nations, to welcome buffalo to once again live among us as Creator intended by doing everything within our means so we and buffalo will once again live together to nurture each other culturally and spiritually. So the Buffalo Treaty is an example of Indigenous law at work. So Indigenous nations had and continue to have systems and practices of law internal to their communities. They also have traditions of transnational law, that is, law between Indigenous nations. So treaty making has historically been an important aspect of what I refer to as inter-Indigenous transnational law. So when Europeans began entering into treaties with Indigenous peoples, they carried on not only long European traditions of treaty making, but Indigenous traditions of treaty making as well. And the Buffalo Treaty is a contemporary example of this transnational Indigenous law at work. So the treaty acts as an assertion of Indigenous law by articulating standards and norms derived from Indigenous legal traditions and worldviews. So for example, the treaty states, we collectively agree to perpetuate all aspects of our respective cultures related to buffalo, including customs, practices, harvesting, beliefs, songs, and ceremonies. So this is notable, I think, as many customs, songs, and ceremonies have important legal dimensions. So they often act as sources of legal principles and legal reasoning. So the treaty also speaks to land and resource use on both sides of the Canada-US border. So in this, the territorial scope of the treaty tracks Indigenous geographies. So among the initiatives supported by the treaty signatories was the reintroduction of buffalo to Banff National Park. So that's just a quick overview of some of the Canadian Indigenous legal perspectives on something like the reintroduction. So now I'll talk a little bit about what I've called here the overlapping law, shared jurisdiction, and reconciliation. So in the Canadian context, there are geographic regions where multiple legal orders are working at the same time, at times in relation to the same subject matters. Right? So we have many legal orders in the same geographic spaces, speaking at times to the same issues. So where multiple legal orders exist in this way, they always sit in relationships of tension and accommodation. Right? They accommodate each other at points, they resist each other at points, there's tension between them, and that's what has to be worked out. So achieving reconciliation between state and Indigenous legal orders requires taking the fact of legal pluralism as a starting point. That's the starting point that we have to work with. So in a practical sense, I think this means clearly identifying legal barriers to the recognition of Indigenous legal orders and drawing on examples of where those barriers have been overcome. So in the rest of this paper then, I'm going to outline how I believe projects like the reintroduction of the buffalo can play a role in these processes. So what are some of those existing legal barriers then to the recognition of Indigenous legal orders? The Truth and Reconciliation Commission, in its 94 calls to action, called on Canada to repudiate harmful principles such as the doctrine of discovery and terra nullius. So I think if we think through why it might have done that, we can sort of shed some light on the question of how to move toward meaningful reconciliation. So why did the TRC make this call? So first step in this regard is identifying where the doctrine of discovery is still alive in Canadian law. Now, in its simplest form, the doctrine of discovery says that European powers gained territorial sovereignty and legal authority over lands in North America by discovering them. Terra nullius is a complementary doctrine through which lands were categorized as legally vacant. So this is a crucial prerequisite to discovery and the answer to the question, how can a continent full of people be discovered? So though the doctrine of discovery in its simplest form might seem like an antiquated idea, it still animates much judicial reasoning on Indigenous rights and continues to shape the relationship between Indigenous peoples and the state in important ways. So the doctrine became an explicit part of Indigenous rights law in the common law world in 1823 in an American case, Johnson and McIntosh, where Chief Justice Marshall said, the rights of the original inhabitants were in no instance entirely disregarded, but were necessarily to a considerable extent impaired. They were admitted to be the rightful occupants of the soil with a legal as well as a just claim to retain possession of it and to use it according to their own discretion. And it's interesting to sort of bracket there that that's now where we've come to in Canadian law as of about 2014, right? Recognition of land rights and control of the territory where those land rights exist. So almost 200 years later, Chief Justice Marshall carries on but their rights to complete sovereignty as independent nations were necessarily diminished. Right? So upon discovery, their rights as sovereign independent nations were necessarily diminished. So this decision then shaped the Canadian approach, profoundly shaped the Canadian approach. So discussing the nature of Indigenous land rights and Crown authority in Guérin, the Supreme Court cited Johnson in stating that the principle of discovery justified these claims and gave ultimate title in the land in a particular area to the nation that discovered and claimed it. And following the constitutional recognition of Aboriginal and treaty rights in 1982, discovery continued to animate the approach to the interpretation of Section 35 rights. So this is done in two ways. In Sparrow decision, for example, the court justified the Crown's capacity to unilaterally infringe Aboriginal rights subject to justification on the basis of discovery, explicitly citing Johnson and McIntosh as justification. And in creating the Aboriginal title framework, the court looked to the date of the assertion of Crown sovereignty as the time when Aboriginal title would be established. So they relied on something called the crystallization thesis that said that Aboriginal title crystallized when Crown sovereignty was asserted. So this notion that Crown sovereignty could, by mere assertion, come to fix Aboriginal land rights in that way is itself deeply rooted in the doctrine of discovery. So this then came to shape the doctrine of the duty to consult, which of course impacts anything that we talk about when we talk about wildlife management and Indigenous peoples. So the courts repeatedly emphasize that the duty to consult does not include a veto power. So what this framing means is that the Crown retains a power to act unilaterally in the face of Indigenous opposition. Further, under the consultation framework, the courts insist that they hold the power to unilaterally determine the relative rights and obligations of the parties. Indigenous rights are asserted until such point as they're proven in court, while Crown entitlements are assumed. So the legitimacy of this kind of unilateralism is based on a hierarchical organization of legal systems. So while the courts have undoubtedly pushed Aboriginal rights forward in important respects, often in the face of intransigent state actors, the doctrines of discovery and terra nullius are ingrained in Section 35 jurisprudence. And this unilateralism is grounded in pernicious legal fictions associated with the doctrine of discovery. This, I argue, poses serious problems for reconciliation. And this is why I think the Truth and Reconciliation Commission pointed to renouncing those doctrines in its recommendations. So how then might we follow the TRC in repudiating these principles? Right? This is sort of some of the backdrop. If we want to take the TRC's recommendations and move forward on this, how might we do that? So one option, I think, is to work outside of the Section 35 framework, to look at different possibilities. Increasingly, for example, the United Nations Declaration on the Rights of Indigenous Peoples is cited as a source of foundational substantive norms that can guide Crown Indigenous relations. So self-determination and free, prior, and informed consent, for example, provide a legal language through which Indigenous people are now voicing their claims to control affairs in their territories. And with the federal government committing to UNDRIP implementation, questions about what this will look like are now top of mind. And now, while the definition of consent is still being contested, and the relationship between UNDRIP and Section 35 is very much up in the air and unclear, what does seem clear is that UNDRIP envisages legally pluralistic spheres. So the unilateralism that grounds Section 35 is not present in UNDRIP. Similarly, when the TRC calls for a repudiation of doctrine of discovery, it's calling for a repudiation of the hierarchical ordering of legal systems and the unilateralism of Crown sovereign authority as it's historically been understood. So these are alternative norms, I argue, which require that legal authority be negotiated rather than dictated by the state and the state's courts. So reconciliation requires moving beyond that unilateralism to models of negotiated jurisdiction which reflect the fact of legal pluralism. Okay, so let's bring that back then to the buffalo. This is sort of the journey and the backdrop as I see it, and let's bring it back to the buffalo. So the reintroduction of the buffalo to Banff National Park included elements of both Canadian state law and Indigenous law. So the Buffalo Treaty is aimed at the reintroduction of buffalo in sites across the region. And this is being undertaken to reinvigorate Indigenous cultural, spiritual, and legal orders. As we've seen, in some sites, this can also require significant movement from state law. So as Parks Canada explained, and I quote, making sure that bison received proper blessings before they returned to the Banff landscape was a key part of the project. Parks Canada hosted a blessing ceremony in the shores of Lake Minnewaca with Buffalo Treaty signatories and celebrated at a sacred ceremony on the shore, at Elk Island to mark the departure of the herd to Banff. So both state and Indigenous protocols had a role to play. So while co-management regimes under modern treaty land claims agreements are important, and we'll hear more about those from John, those agreements are impractical or undesirable for many Indigenous nations. They tend to happen in the context of modern treaty or land claims agreements, sometimes outside, but they're not always possible. So sometimes there are other possibilities to look at, and I think the Buffalo Treaty example is showing that there's other ways that these might move forward. So there are many other examples like this taking place in national parks. Jasper National Park, for example, closes a section of the park for a week every year to allow for traditional hunting to take place. Traditional harvesting in Kluane National Park has also been negotiated. So these are some discrete areas where the exercise of Indigenous jurisdiction is being negotiated and recognized in national parks. So now in these examples, Indigenous peoples are working within the existing national parks framework to create space for the exercise of Indigenous law. Now in other examples, Indigenous people have asserted their law as the primary source of authority and pushed the state to work within those legal frameworks. So one example here is the creation of what are called tribal parks. So the Tlayoquat, Chilcotin, Haida, Doig River First Nations have established tribal parks. Now tribal parks are areas of Indigenous jurisdiction that are subject to Indigenous law, and they are, as of yet, with only one exception, not recognized at Canadian law. So the park that's best known is probably the first one created by the Tlayoquat. This is on the west coast of Vancouver Island, and this was in 1984. There was a dispute over logging of old-growth trees on Mears Island off of the west coast of Vancouver Island. The Tlayoquat blockaded the island to try to prevent the logging, but they also declared that the island was a park under their jurisdiction. Now, they won an injunction against the logging in court, and the injunction has stood to this day. The courts did not explicitly speak to the tribal park. Yet, it continues to be managed and has since 1984 as a tribal park at Tlayoquat law. They've since established 3 more tribal parks following this model. A slightly different model has happened with the Haida. The Haida also declared a tribal park on the northern part of Haida Gwaii. There, after about 20 years, the BC government decided to recognize the park, and they did so by recognizing the park at British Columbia law. Right? So they legislated the park into existence at British Columbia law. What's interesting is if you look at those co-management documents, they explicitly state that it's a park under 2 bodies of law. So those co-management agreements say this is a park at British Columbia law, this is also a park at Haida law. Right? So it's an explicit recognition that we have this overlapping sort of shared jurisdiction between the legal regimes. Another example is the Chilcotin Tribal Park. They declared a park to 90,000 hectares of land outside of the lands that were recognized as Aboriginal title lands in the 2014 decision. And we don't know yet what's going to happen with that. There's no movement from the provinces or federal government, so we just don't know. So just to wrap up then, whether created under federal, provincial, or Indigenous authority, what the approaches that I've discussed here have in common is that they move beyond a unilateral approach. So they allow for terms of engagement between Indigenous peoples and Canadian governments to be subject to negotiation. That is, negotiation not constrained to the exercise of particular rights, but jurisdiction, and along with it the terms of coexistence, are being negotiated on a small scale in these examples. So these examples also illustrate, I think, that developing notions of self-determination and free, prior, and informed consent need not disrupt wildlife management in Canada. So frameworks for reconciliation in wildlife management can be developed on the basis of negotiation in relation to these sorts of specific locales and subject matters. Thank you.
Thank you, Rob. I'll just queue up John's presentation here and we'll keep going.
Well, good morning. I'm very pleased to be here. It's very nice to be back at an Institute symposium. It's been a while for me. I thank the Institute for their kind invitation to give this presentation to you. I note David Wright's comments, and of course Dean Holloway as well pointed out when we started yesterday that we're on the traditional lands of Treaty 7 First Nations. And I think I would just point out to all of you that no matter where you are for your work or wherever you live, that if you scratch a little, you're going to find that you're on Indigenous lands just about everywhere in Canada. And that's important, I think, because what I want to talk to you about in a broad sense, although my focus will be primarily northern, is I want to talk about reconciliation. And in particular, I would just say that the jurisprudence resulting from Section 35 has made the need to seek reconciliation with Indigenous peoples in Canada very clear. You know, in the Vanderpeek case, the Supreme Court of Canada explained that true reconciliation accounts for both the Indigenous and the settler perspective. And in Beckman, the court said that the goal of reconciliation is to foster a mutually respectful, long-term relationship between and to bridge the cultures of Indigenous and non-Indigenous peoples. Now, we're here, of course, at a symposium that's primarily focused on wildlife law, and I expect that you'll agree that the need derived from from Section 35 and the jurisprudence to pursue reconciliation with Aboriginal peoples is much broader than simply wildlife management. But wildlife law is part of the story. And I'm going to do my best to try and outline how the northern chapter of that story has played out in the short time that's available to me. I suggest and I hope that when I finish, you will all agree that what's happened in the North is a very positive chapter in the effort to try and achieve reconciliation. If Canada is going to retain wildlife and habitats on its landscapes, that goal is more likely to be achieved in the north. And as I'll note in a little more detail in a few moments, over 50% of Canada is subject to comprehensive land claim agreements. If I were a little more adept with PowerPoint, I could have put a map in for you last night, but I couldn't figure out how to copy it into the PowerPoint presentation. I just suggest that you go to Dr. Google and just look for map of comprehensive land claims in Canada, and you'll, at least that's the authority I'm citing for that comment. But what you'll find is that all three territories, Labrador, 2/3 probably of northern Quebec and pockets in British Columbia are subject to comprehensive land claim agreements. And I will suggest to you that these agreements move the goalposts on wildlife management and protection. I'm not going to focus on enforcement in the courtrooms in the ways that we have over the last day or so, but I still want to suggest to you that the best way to achieve wildlife management outcomes is to set your goals and determine your actions collaboratively. Comprehensive land claims all institute co-management process, and many of them include co-management institutions as well. Broadly speaking, these claims institutionalize collaboration. There are still bad actors out there, of course, and the need for the courts and enforcement won't go away, but when it's necessary to take action to enforce some kind of compliance with collective goals for the management of wildlife or goals for outcomes in relation to harvesting activities, there are a variety of ways to get there. And I will talk very briefly over the next few moments. I'll give you a couple of examples of the ways in which some of the land claim organizations have set the scene for them to manage those things themselves using their own community-based and indigenous approaches to enforcement. So let's just move through the PowerPoint, and I'll use the points to illustrate my thoughts. These co-management systems obviously are the result of comprehensive land claims. I do want to emphasize that co-management is part of the public and not Indigenous governance. The institutions created by land claims very often reflected in the wildlife legislation of the jurisdiction are public government institutions. They're funded by, in large part, the Government of Canada, or in some cases the territories or provinces contribute to them, but they're public governance. These are not institutions applying Aboriginal or Indigenous laws. And I would say as well, if you have some sense of the history of the way that land claims have evolved, these systems really reflect a trade-off. When Aboriginal people went to the land claims tables, wildlife was first and foremost in their minds. Very often, wildlife matters were negotiated early on, sometimes first, among the lists of matters to be addressed by claims. And in most instances, where the wildlife provisions came into force at the time that the settlement legislation was enacted. To give you an example, in the Mackenzie Valley of the Northwest Territories, there's a whole series of other tribunals, land use planning, land and water regulators, environmental impact assessment tribunals that all had to wait for subsequent legislation, which wasn't enacted until years after the land claims were settled. But in all instances, wildlife management requirements, wildlife management frameworks and systems came into force as soon as the land claim was given force by Canadian law, and that arrangement was very deliberate. These co-management systems contribute to reconciliation by integrating Indigenous and state interests in wildlife and habitat management. I'm going to talk about what I call two wildlife management paradigms. First off, of course, from time immemorial, Aboriginal peoples managed wildlife and habitat in their own ways based on their spiritual, cultural, and community values, and based on their intimate knowledge of the land and the animals that they relied on. Euro-Canadian wildlife management rules emerged from a different tradition and from different belief systems. I'm going to refer to that as a state system. It too has evolved over time as Sarah mentioned yesterday afternoon, I did a review when I was working with Searle of the evolution of wildlife law in Canada, and there's no doubt that our attitudes and approaches to wildlife and wildlife regulation have changed considerably since the time of Confederation. But nevertheless, it's a completely different belief system and approach to wildlife management than that found in Aboriginal communities. And it's this state system, of course, which was applied and enforced by the courts as Canada expanded west and north. These paradigms coexisted uneasily, and the community system, Aboriginal or Indigenous system, continually gave way as law enforcement moved north. I'd just say briefly, by way of an example, in the late 1970s, there was a uranium exploration boom in the Kiwaitan-Kivalliq region of Nunavut now, and the people of Baker Lake, who depended on caribou for sustenance, went to court and sought an injunction to try to prevent the exploration because the caribou food source was no longer available to them, their argument being that the disturbance resulting from industrial activity was in fact driving the caribou away. The counter-argument that was advanced by government in the injunction matter was that in fact the problem was not caused by industry but rather by overhunting. And there really were nobody other than Aboriginal people hunting there, and it became rather a political issue. In the end, the injunction application failed. At the time, it was before I had gone to law school. I was working as a wildlife biologist for the government of Northwest Territories. And I would just say that within 2 years, the government changed the way that they did their caribou surveys. And lo and behold, they found out that they had, throughout that period, been undercounting the caribou by at least 100%. And that, in fact, it wasn't overhunting causing the problem at all, and that, in fact, the Aboriginal people had actually been describing what was really happening on the ground. Now, what does that mean? The Baker Lake case actually, of course, helped in respect of establishing the existence of, or the potential for the existence of Aboriginal rights in the Nunavut area. But in the end, I guess I raise it with you simply because I want to emphasize that there really are two different ways of knowing what's happening out on the land, and that the community view, the Aboriginal harvesters' view of what's going on out there has a lot of validity and continues to this day in the North. After the 19th century, the dominant wildlife conservation and management system rejected market hunting. Buffalo were slaughtered off the landscape. The passenger pigeons were gone. And the ethic of the conservation ethic came to the fore. We never had privileged access to hunting here in North America in the way that happens in Europe. So we came to a view of wildlife as a public resource owned by the Crown and managed by way of a licensing or permitting system, which was intended to make wildlife equally accessible to all. That framework leaves no room for special entitlements for Aboriginal people. Hunting, in addition, is imbued with concepts like fair chase, and that has other implications for the way that you manage wildlife. This system requires centralized authority in either Parliament or the legislature, enforced by game management officials in the courts. It's bureaucratic, it's hierarchically organized, it's scientifically based, and the managers ultimately are separated from the users. In the community paradigm, local or community-based wildlife control is linked to territory and to land tenure. So the people who manage wildlife use it and live with it and depend on it. And knowledge of the resource is secured by collective use, hunting, eating the product of the hunt. Stories, culture, knowledge is shared, and decision-making is shared in this context as well. These systems are resilient, they're adaptive, they're community-based and enforced. And in this system, the users are the managers. And this approach never entirely disappeared in the North. So what happened when the state paradigm moved north? Well, there were a few wonderful cases by Judge Sissons from the 1960s where he questioned the applicability of the game ordinances of the day to Inuit. In particular, some cases involving polar bear in the Arctic islands. And the reaction from the Government of Canada was to amend the Northwest Territories Act in 1960 and to change it in a way that really framed the relationship between Aboriginal users of wildlife and the state, the territorial and federal governments, in the same way, or pretty much the same way as that system had evolved in the prairies after the Natural Resources Transfer Acts. So the effects from territorial game ordinances and federal laws were, the restriction of any kind of commercial harvests, the imposition of seasons for harvesting wildlife, gear restrictions, what kind of weapons could you use? I can't tell you how many hours I've sat in meetings with people arguing about whether or not it was fair and reasonable to shoot a caribou with a .222 or whether you needed a higher caliber, a bit larger caliber weapon to do that. Those were the sorts of inanities that the system drove us to. We had bag limits and progressively tighter restrictions. There were wildlife management areas like sanctuaries established where there was no hunting allowed, or some species were protected, like the Thelon Game Sanctuary established in 1929 to protect musk oxen. And what was protected in the Northwest Territories Act in 1960 was Aboriginal hunting for food on unoccupied Crown land. But even there were cases in Yukon in the 1980s where the argument was made that provincial and national park, or territorial and national parks and sanctuaries were actually occupied because of the legal framework that had been imposed on them in order to try and prevent Aboriginal hunting in those areas. The only game that could be restricted under the system in the Northwest Territories Act of the day had to be game declared to be in danger of becoming extinct. But in the 1960s, the Government of Canada, by order in council, declared barren ground caribou the primary food source for almost all the Aboriginal people in the NWT and Nunavut. Musk oxen, next biggest large game source, and polar bear and bison, wood bison, to be in danger of becoming extinct. The effect of that was, of course, that they were managed under strict quota systems and that harvesting by Aboriginal people was restricted. So, and as you know, before 1982, Aboriginal rights could be restricted or extinguished by Parliament or in the provinces via Section 88 of the Indian Act. And there was no justification required. The result, an erosion of Aboriginal harvesting rights. And I'll just speak to you briefly about a case called Sakia. It's a wonderful case. Mr. Sakia was a Treaty 11 participant, lived in Detta, just outside of Yellowknife. He'd been working in the mines and he was injured, and he came home in the springtime. And of course, in springtime, Aboriginal people traditionally harvested migratory birds. At the time, the Migratory Birds Convention Act prevented that. It didn't stop Mr. Sakia, and he went out and shot a duck. Got caught by the game warden, as he called him. I actually saw Mr. Sakia in a movie they made of him, the Yellowknives Denny did. He was about 101 at the time and a delightful gentleman. And he said, that I got pinched by the game warden, was the way he put it. And he said, the only satisfaction I got out of that was, he said, he caught me before I had retrieved the duck. And he said, he told me that he wanted that duck, and I told him if he wanted it, it, he could go and get it himself because the water was cold. And I used to work in the courthouse in Yellowknife, and at the time they had a display case on the way into the courthouse, and they actually had a mount of a female mallard duck there with a little plaque under it saying the Sakia duck. Now I don't know whether that was actually the one that the game warden retrieved or not, but anyway, aside from the anecdotes, the interesting part of the case was that, of course, Treaty 11 had been signed in 1921. And the Migratory Birds Convention legislation had been enacted in 1917. And the promises in the treaty, of course, were that the Aboriginal people could continue to hunt and fish as they had forever, subject only to lands being taken up and the usual things. And so, you know, when the case went to court, the question that the court had to deal with was how could the Crown go out and negotiate a treaty with the Aboriginal people north of Great Slave Lake in 1921 and promise them in the treaty what they'd already said wasn't possible in their own legislation in 1917. The matter went to the Northwest Territories Court of Appeal, where Justice Johnson said, well, seems sort of like a case where the left hand didn't know what the right hand was doing. But Mr. Sakia's conviction was upheld nevertheless, and the matter went on to the Supreme Court of Canada, which simply affirmed the Court of Appeal's decision. So there you have it. You know, that was the way things worked before 1982. And land claims in the Northwest Territories, the first of them, 1984, was the Inuvialuit Agreement. Just have a list here to show you. There's still areas in the NWT where comprehensive claims are not yet settled, but there are no areas in the Northwest Territories where negotiation isn't well underway to settle comprehensive land claim agreements. Yukon has its umbrella final agreement, which covers the whole territory, and the Nunavut agreement covers that whole territory as well. Nunavut by itself is 30% of Canada. If you add James Bay, Northern Quebec, the Nunavut and the Nunatsiavut agreements, Nisga'a and other British Columbia agreements, that's why I came to the 50% of Canada. And these are public, the co-management regimes that I'm going to talk about, or am talking about, are public government regimes. They're not Indigenous. You know, the other thing is that the Aboriginal rights granted or recognized by the claims apply with some special arrangements on Aboriginally owned lands as well, and huge areas of land are owned. My client, the Kitikmeot Inuit Association, owns 101,000 square kilometers of land itself. You know, that's larger than the province of Nova Scotia. So, if you look at what Aboriginal people did through comprehensive land claim agreements, they sat down and systematically rolled back what the state paradigm had done to their harvesting rights. And so, you know, what bag limits, seasons, you name it. What remains, of course, by way of limits on harvesting are conservation requirements, public safety, and in some cases, humane harvesting. So no licenses, seasons, gear restrictions can be imposed on a claim beneficiary. In many instances, of course, we have local committees of harvesters established, and they have a role in allocating the harvest itself. And in some instances, that role goes beyond that to a role in actually regulating the rights of harvesters, such as under the Inuvialuit Final Agreement, where the Hunters and Trappers Committees can make bylaws that actually are enforceable under territorial law and which can, in fact, regulate the exercise of Aboriginal rights by their beneficiaries. So through land claims, the community paradigm made a very big comeback. Now, I'll leave it to you in the paper. All three of the territories have revised their wildlife legislation since land claims were settled. I'd commend to you, if you want to have a look at it, the Nunavut Act in particular, which in Section 6, I believe, includes a whole series of concepts which were derived. We actually got a committee of elders together, talked about their mores, their approaches and ethical framework for the way that wildlife harvesting should take place. The Inuktitut words for those concepts or principles were secured, and they were actually enshrined in the legislation, but only insofar as the courts or anyone enforcing or interpreting the legislation is asked to use them for interpretive purposes. Okay, they're not substantive requirements. They stop short of that. But it is a very, very interesting way to approach guidance for wildlife management officials, for example. I want to talk just briefly about the reconciliation piece. I know I've just got a minute or so left. You know, in the most recent case, the First Nation of Nacho-Nyak Dun, I'm just going to call it the Peel versus Yukon, the Peel River decision, Peel River watershed decision. Very important. I think the court had some things to say there about, you know, they identified the umbrella final agreement in Yukon as a model for reconciliation because agreements falling under the umbrella final agreement are intended to foster a positive and mutually beneficial long-term relationship between the signatories. They went on to say some very constructive things about co-management regimes, saying essentially that they're part of the bargain that was made at the land claims table, that they're subject to that if any change to those arrangements want to be made, they're subject to the same kinds of constitutional protections as the more substantive wildlife rights held by the nation that entered into the land claim. And I think that you know, the Peel case says some very important things about the future of co-management, and in particular because that case was one where the Yukon government was attempting to rewrite a land use plan that had taken quite a while to develop. You know, the court said explicitly that government, the state system, must deal in an honorable way with the process that's set out for co-management as well. And, you know, to give you an example of that, the Wekiji Renewable Resources Board, it's established by the Tlicho Land Claim Agreement just northeast of Yellowknife. They're dealing with crashing caribou populations, Bathurst herd in particular. Tlicho government has the ability to come to the Renewable Resources Board and put wildlife management proposals forward. They did so in 2014 in collaboration with the government of Northwest Territories. And the issue was essentially the requirement to go to a total allowable harvest of caribou of 0. So the dog rib are caribou eaters. Their primary food source is caribou. This is a food security issue for Northern Aboriginal people. And in this case, they came forward to the board and said, we want the total allowable harvest to be 0. And I'm counsel to the board. Our scientific advisors were saying there's room, just given the way the statistics work, there's room here for some cultural and ceremonial harvest if the dog rib or the Tlicho government are so inclined. We put it to them at the time and said, look, you know, on the basis of the numerical explanation, there's room for a harvest of 30 to 50 caribou. You know, you have an annual gathering, you know, for your nation. You could harvest some caribou, and some of the old people could have caribou. And the Tlicho government representative said, no, we don't want to do that. We want to make the case that we're here and we're going to manage this resource properly, and we want to show everyone that we'll step up as well, and we'll show that you know, we'll take the hit. So you know, I think it's very important to understand that the Tlicho, in this case, are ready to, to play their role in these hard decisions that sometimes have to be made from a wildlife management standpoint. So, to conclude quickly, these claims are a mechanism for Aboriginal people they have been a mechanism for them to reestablish local control of wildlife. I admit, in light of Robert's comments, land claims are a rather unique context. They're simply not going to be possible in the settled areas, more settled areas than south of 60. But there are some important lessons about the approach to reconciliation that could be drawn by the way and that land claims were structured and the experience under them. I think that my final point would just be that I really believe that in areas with land claims settled, that the potential for collaboration and positive outcomes in respect of wildlife, keeping wildlife on the landscape, which I hope is something we'd all aspire to see, is a stronger possibility. So that's it. Thank you.
Okay, welcome, Bill. 25 minutes. I'll give you 5 minutes more. Okay, great. Bill Snow.
Ambawa Stitch, Dagun Chawa, Minta Wincha Stubby. It's good to be here. My name is William Snow, and I'm the Consultation Manager for Stoney Nakoda Nation, and here to talk about the Grizzly Report that we had completed for Environment Canada. And so I just want to thank the Cyril, the Canadian Institute for Resources Law, for inviting me here to share in some of the experiences that we've had in working with various groups. I do have a few points I'd like to make on, or just add to Rob's presentation, but maybe I'll save that till the end, just to add on a few points to bring to add to the discussion. So we'll get started. The Grizzly Report that we completed was part of a process that began in 2014 when grizzly bears were listed as a threatened species, and the Stoney Nakoda applied for a program called the Aboriginal Funding for Species at Risk. It's good and it's bad. The good part is that we're able to do a traditional use study for a very important species in a given project area. But the bad part about it is that we have to wait until the species becomes threatened before we start really applying a traditional use kind of study to this species. The project area, the Kananaskis area, is immediately south of our Stoney Nakoda Reserve at Morley, which is just 60 kilometers west of Calgary here. So it's very close to our main reserve, and we're very familiar with the area, and we have not accessed a program like this previously, so it was a bit of a learning experience on our side. And we, like many other groups, have observed incidents happening within the park, namely between park users and bears. And we've had a lot of those kind of articles come out in the media about some of the conservation officers were talking about some of their vehicles being overturned, their bumpers being ripped off, but those are at the parking lots. That's also happening out on the trails with bears following park users around. So we wanted to add a slightly different explanation, a different reasoning behind what we believed was going on. And so part of that was to use this study to sort of re-examine our understanding of grizzly bears and grizzly bear habitat in that particular area. I don't know if I'll be able to go through all slides, but I'll try to cover as many points here as I can. And of course, just a map of the project area down in the Spray Valley. The particular area that we were focused on is the Galatea Creek area, which I'll call up here. When we completed the grizzly study, we talked about our main focus was to look at the objectives and the recommendations. So we entitled the report Enhancing Grizzly Bear Management Programs Through the Inclusion of Cultural Monitoring and Traditional Ecological Knowledge. And by that, I think one of the main points here was to use traditional environmental knowledge to provide insight into potential management of the resources identified and develop a set of recommendations to assist in grizzly management. We didn't want to create another study just for the purpose of creating another study. We wanted to create a study where we would be able to have some influence over management practices and how parks were managing species and understanding wildlife and wildlife habitat. So there's any number of studies out there on any number of subjects in mountain parks, in waterways, in foothills, and any number of species. But we were looking at this more from the policy angle. How can we change policy so that we can bring in that traditional knowledge aspect so that that is a consideration if policy is going to be changed. I'm only going to go over there's 6 recommendations in all from the report, and I just want to cover off 4 of them because those I think are the most, there's some background to each of them, but they're pretty important. And I also wanted to get into a little bit about the background of the report. When we talk about the grizzly study, it was necessary to provide some background into historic government policies that have impacted traditional knowledge. And one of those areas is this that we get into in the report as we talk about prejudicial government policies, particularly from the period from about 1885 till about 1951, where we had very restrictive policies, primarily set out in the Indian Act. In 1927, the government enacted legislation to prohibit First Nations people from having legal representation. Despite these recommendations, the Stoney Nakoda successfully protected their hunting rights in 1932 in a case called Rex versus Wesley, with the great help of Mark Benepeacock, a lawyer from the Calgary area who donated his services. That is mostly captured in a book by Fritz Panicock. Book is called Behind the Man, and I believe it came out in 2008. It talks about Mark Benepeacock and talks about his daughter, Ruth Gorman, and also another activist during that time in the 1930s and 40s was a man named John Laurie. John Laurie Boulevard here that connects the northwest to the northeast part of Calgary. That's who it's named for. And I also wanted to include a picture of Banff Indian Days from 1935, where there was a naming ceremony done for Mark Benepeacock, who is, I'm not sure if this pointer will, this gentleman here, and we have other Stoney dignitaries. And in the background is Cascade Mountain, and this is, of course, the Indian grounds just to the east of the Banff town site. The Stoney Nakoda, of course, continue to hunt, fish, and trap in their traditional lands and exercise rights set out for them in Treaty 7. So just to know that we've included a portion of this review in the report, in the Grizzly report. I think it's important because not all of the elders in our community were really free to or really wanted to speak about some of their traditional knowledge, because a lot of them still have a fear that they're going to be persecuted for sharing that traditional knowledge. So that's still a very real consideration in our communities, hearkening back to those days when of these prejudicial government policies, primarily from, like I said, 1885 to 1951. But you could argue that the 1961, when we had some policies that were amended at that time. One of the recommendations that we talk about in the report is restricted activity, particularly for Galatea Creek, noted here of the Government of Alberta mapping system. This is Highway 22 running north and south. Up over here is Wedge Pond, and to the west here is Galatea Creek. That was our main focus of our study area. And one of the things that we also talk about in the report is some of the differences between Western science and traditional knowledge. And in order to get into that kind of background, we relied on the writings of Dr. Marie Batiste, Daniel Wildcat, and the late Vine Deloria, and their bibliography of some of their work is included in the report. One of those areas that we try to focus on and try to explain is that one bullet there talking about the interchangeability of place. In a Western scientific system, you have largely you have a designation of land through a formal designation. So you can have a recreational area, you can have a park area, you can have a commercial or industrial area. So those are changing according to whatever group wants to change that land use to. For First Nations, the understanding of place is different. It's more fixed. So places like the Banff National Park, the Banff town site, that's always been considered a healing spiritual place because of all the waters that encompass that particular area. Lake Minnewaca, Minnewakan, that's the Lake of the Spirits. Our Stoney name for the Banff area is Minerpa, and that's to describe the waterfalls that fall from Cascade Mountain. The hot springs nearby at Sulphur Mountain, and Cave and Basin, a cave that's closely associated with the hot springs. Those are places where Stonies would go and do stages of life ceremonies. And of course the hot springs would be used for physical and spiritual healing. That place is still regarded that way today. That hasn't changed. That fixed notion of a healing spiritual place, that is still how our understanding of the Banff town site is regarded. And so, in the same way, for Galatea Creek, when we look at that area, that has a special cultural importance for grizzly bears. And that's what we try to touch on in the report. The reason why we wanted a restricted activity is because we know that animals, wildlife, have a cultural function on landscapes as well as environmental. So these are the things that we've tried to talk about and give our reasons behind restricted activity. anybody can go out there and say, well, there's too many people, from June 5th or August 15th to August 30th, there's too many people, and we need to shut down a couple trails. Anybody could say that, but what we're saying is we know that there's a special time frame up there when grizzly bears are going to be up there. So that's the best time to do a restricted activity. One of the other recommendations was ongoing cultural monitoring. And cultural monitoring is a process that we came up with in order to describe some of the ways that we were, the process that we were following in order to gather information and then to share and disseminate that to the report. So we put a bit of the cultural monitoring definition there from the report, but we understand that, cultural monitoring is going to mean different things in different places. So in Alberta, it might have one meaning. In northern BC, it's going to have another meaning. In NWT and Yukon and other areas, it's going to have a different meaning. Could be called cultural monitoring, could be called community-based monitoring. So there's a whole range out there. It's not a hard and fast rule. It's not formally ingrained as a process. We just came up with this because we had to come up with some type of explanation around what we were doing in order to explain in the report. So we try to cover as many of those elements as best we could. Cultural monitoring, I guess, is a part of that process is involved in ceremony, and this is one of the ceremonies that we took part in with Environment and Parks out in the Evan Thomas area last spring, April 2017. We had a good little turnout there just before a fire program came in and to regrow some of the vegetation in a particular area. The reason why we do the ceremony is because of our relationship with the land. We need to do some of these ceremonies in some of these special places so that we know that we'll have that regrowth coming back from a cultural perspective. And this was done in other areas previously. So trying to get these kind of ideas across to regulatory agencies like Parks Canada, Parks Alberta is it's challenging, but I think we're making some headway here over the years that we've been working with them on various projects. One of the other recommendations is connectivity that we had talked about. We didn't get any hard and fast rules around where or how big, or if they should be overland passes or underpasses. But generally, what we're saying is we want more connectivity, especially in the Kananaskis area. We have all these linear developments, highways, transmission lines, hydro, pipelines. We have all these linear encumbrances without any real thought around how wildlife gets around all of that. So it's very good to see some of the initiatives coming up or being considered, like the Overland Wildlife Pass at Dead Man's Flats that's being proposed. So we're very much in favor of that because we know that there's places where wildlife use as migration routes. And so not having had a lot of chance to participate in a lot of these different ecological studies, wildlife studies, so that we can talk about these migration routes has always been a problem, but hopefully that's changing. when we think about wildlife passages, we think about the overland crossings in Banff National Park, for which there are, are a fair number of them, especially between Banff National Park and Lake Louise. But outside of that, there's not a whole lot of wildlife crossings. Jasper, in and of itself, I can't think of one. There's a number of underpasses, but not overland passes. So this is what we're talking about for connectivity, and the connection from connectivity to Aboriginal and treaty rights is that if we can't go into these places to do hunting, as we have done in our past, then we're not using that land in the same way that we have done traditionally. And if we don't have animals on those landscapes, like I said, we don't have that environmental and cultural function happening on landscapes. In fact, you're taking away some biodiversity when you restrict that activity, when you take animals, wildlife, birds, and fish out of certain landscapes. One of the other recommendations is cultural awareness. To bridge the gap in providing First Nations history and perspective. Like the speakers before have noted, very important to try to link policies and legislation to some of the areas talked about in documents like the Truth and Reconciliation Commission report, the 94 calls to action, as well as the 46 articles from United Nations Declaration. Oftentimes, those are left out in policy development or legislation. It's only looked at in a peripherally, towards the back end when we get into policy discussions. In my talks, our talks with the Government of Alberta, especially on topics like the consultation policy renewal, we continually bring these things up around, how do we incorporate, like my question the other day, how do we incorporate Article 24 into a biodiversity framework? How do we protect and conserve animals or wildlife, plants, and minerals that are traditionally used? So there's no easy answer, there's no easy fix, but I think, with all the resources and all the brain power of all these young people here, I think we can figure out a way to incorporate a lot of these things into these current issues. We do regularly take part in the Bear Day out at Canmore, and we are planning to be out there again this year, planning on sharing a little bit of information about the Grizzly Report, as well as some of the other updates that we have on the bison reintroduction. It's a good way for park users to come out and hear and see what projects we're up to concerning wildlife. So cultural awareness, I think, is a big key component, because not all universities have Native Studies as a faculty. And one of the important one of the projects that I'm doing a lot more work in is with the Canadian Mountain Network Initiative up at the University of Alberta, that talks about the Mountain Studies Initiative, and we do a fair bit of work with them on their NCE application that's we just got shortlisted, and we're hoping to continue to work on the application here in the next stage. Also, just wanted to, the outreach is also an important part of what we're doing. We did receive the Ted Smith Award last year, and I continue to go out and do presentations like this for different post-secondaries and different companies and towns in and around the Bow Valley. And I think we're getting some traction around how do we implement rather than why would we consider a grizzly report by the Stonies. Conversation is now moving towards how do we understand those recommendations and how do we do some of them. So some of the discussions that we've been having with groups like the town of Canmore and Banff, Kananaskis Trail Committee are continuing. Those are the groups that are going to actually have to buy into some of these recommendations if they're going to become real. And I think that might be another one of the overlapping law areas where you would say, how would you incorporate some traditional knowledge into our current policy or practice? That might be a way to do it, to Rob's presentation. And so this cultural monitoring process is currently being studied by the government of Alberta and U of A research groups. Environment and parks, we have several different working groups set up under the South Saskatchewan Regional Plan as well as the North Saskatchewan Regional Plan. And we have other research groups within environment parks that are also looking specifically at cultural monitoring. How can that be used not just for grizzly bears, but for other wildlife species? That's the location of the report. It's on the Canadian Mountain Network website. And basically, we are trying to promote the traditional knowledge as an aspect of current research process. And that's it. Thank you. I just wanted to add on a few points for Rob's presentation. The reintroduction to Banff National Park. We currently have a cultural assessment proposal to Environment Canada because the environmental assessment that was done on the reintroduction does not have a cultural component. And so our proposal that went in not too long ago would be to address that gap. So hopefully if the proposal is successful, we'll be doing basically the grizzly report in Kananaskis, but only think about that in terms of plains bison in the reintroduction area. So that's just an update. In terms of the overlapping law section, Stoney Nakoda, we did sign an MOU with Parks Canada in 2010. And from that, we've been able to work on common areas between Banff National Park and Stoney Nakoda. On the Buffalo Treaty, Stoney Nakoda did their signing of Buffalo Treaty in July of 2016, and we were also joined by the Samson Cree First Nation, and we did that signing out in Banff. So where the other bands did the signing in their traditional areas, we did in our traditional area, which is, of course, the Banff National Park area. And it's very ties in more or less with some of our other initiatives around the renaming of Tunnel Mountain. Yarhe Tatanga Wawayage Wakan, Sacred Buffalo Guardian Mountain, is the name that we proposed for Tunnel Mountain. Tunnel Mountain, of course, for which there is no tunnel. And also, I wanted to point out that there is a Stoney Indian Park. You may want to add to the Indigenous listing of Indigenous parks. We opened Stoney Indian Park in the early 1970s. We received a 25 head of buffalo from Elk Island National Park. I believe it was either 73 or 74. And right now, our buffalo herd is right about 100 head that we still manage. And also, we did a panel discussion on the bison reintroduction for International Mountain Day in 2016. And I believe that is also still available on YouTube. It's about a 3-hour discussion, but it's available for people to see and hear. Good, thank you.
So at the risk of battling with rumbling tummies, we do have a few minutes for questions. So I'd like to open up the floor to questions, and I think we probably still have the microphones floating around. Questions for our speakers? Looks like maybe we'll start online. Okay.
There's one. So have a question for John from a viewer asking if you could clarify what the current dispute resolution system used for agreements and bylaws made pursuant to them. Who's responsible for enforcing the agreements and bylaws should they be contravened? Is it community-based or state-based? Are there Indigenous investigators, prosecutors, etc., or some other form of administration of justice?
Thank you. The example that I gave comes from the Inuvialuit final agreement, and it's rather unique in that the bylaws are made by hunters and trappers committees, which are Inuvialuit institutions. They're not public. They're made up of land claim rights holders only. They make the bylaws. They've passed bylaws to deal with hunting of grizzly bears, polar bears, caribou, and other species. And when they negotiated the land claim, they added a provision to it which said that once a bylaw is made by an HTC, that bylaw shall be enforceable under the wildlife laws of the Northwest Territories. So practically speaking, that means that the government, Inuvialuit would decide what they want to do in terms of outcomes and wildlife management, but they then collaborate with the Department of Justice from the Government of Northwest Territories, because the bylaw has to actually be adapted into a regulation so that it can be enforceable and it's actually enforceable under the Wildlife Act. So that's practically how it works. I'll give you one example. As a fascinating case. I was actually still working as counsel for the Department of Renewable Resources. Inuvialuit harvester from Inuvik went across on a north slope. This could have been a law school problem, actually, because the definition of Yukon is that the islands offshore are part of Yukon, but the ocean in that area is Northwest Territories. He was hunting a polar bear. He actually killed a polar bear, a sow and a cub, but he lost track of them in the rough ice, and so he went up on the edge of on a ridge on an island and shot them from the Yukon in the Northwest Territories. And so anyway, I was prosecuting the case, and the very sharp defense counsel pointed out that there was an interesting conflict of law issue here, and advised that his client would plead guilty to hunting without having had a tag. And that the other aspects of the case could be resolved that way. So that's what the government chose to do. The Inuvialuit, however, were not satisfied with that. The HTC was not satisfied with that because they wanted their law, their bylaw enforced, and so they took action individually. Again, through the land claim, they had the authority to regulate the exercise of harvesting by their people. So they called the HTC, convened the HTC, hauled him in front of them, and banned him from polar bear hunting for 5 years. So, I just point that out there. The systems are out there, but similar arrangements are possible in Nunavut for their hunters and trappers organizations. but I don't have the same level of experience with that. So at the moment, I think the evaluate system is a little bit unique simply because it's kind of integrated with and relies on the enforcement capacities of the courts, whereas in Nunavut, if they're going to do the same kind of thing, it's all done based at the community level, and the state system's not involved.
My question is for Bill, and it's with respect to the notion of cultural monitoring. I find it quite intriguing. I think at least the scientific understanding of monitoring is heavily based on objective data, that you either see an animal or you don't, you pick up a hair snag or you don't, etc. So I'm curious how the notion of cultural monitoring reconciles that objective data-driven model with cultural inputs and perspective.
Yeah, cultural monitoring, I guess, was the best term that we could come up with at the time. We wanted it to be more easily understood. I think everyone has a fair understanding of environmental monitoring, and so we had to compromise and sort of talk about that. Our observations were based on our traditional knowledge, our oral history of that area. So when we have you might have a biology specialist or a wildlife specialist walking down a particular trail or area, noting certain things, empirical data, and that's fine. But when our people go out in landscapes, they're doing exactly the same thing, but the reasons to support those empirical observations are different, based on stories, based on names, based on language. And so that's where the difference lies, is that those observations are cultural in nature or supportive of a cultural basis.
Another question in the back.
Thank you. A question for Mr. Donaghy. From some years of watching the situation in the Yukon and around wildlife management, one of the things we've seen in the last decade is co-management recommendations from the Fish and Wildlife Management Board being rejected by the territorial government. For example, around the division of allocations between outfitting harvest and Indigenous harvest, among others. And co-management boards broadly are advisory, if I understand it. Governments typically have the right to reject those recommendations, at least around wildlife. And you brought up the Peel case, which, as you say, the Supreme Court decision and even the Court of Appeal decision, though it reached a different conclusion, were very strongly supportive of the process and of the umbrella final agreement. But at root, well, the land use planning is a very convoluted process compared to wildlife management process, I think. But it seemed to dodge that ultimate question of, are those recommendations advisory and can the government ignore them? And is that an issue that is going to need to be addressed more at some point, do you think?
I think your point's well taken. One of the sort of subtexts for me in the Peel decision is that I think the Supreme Court placed a fair bit of emphasis on the importance of the co-management process and on open, transparent, and honorable application of that process, because in the end, you know, the decision on the plan, the final approval of the plan, of course, will be made by the government. It'll be, I mean, the governments have changed since in Yukon since the rejection of the initial plan happened, but nevertheless, the final decision is for government. And again, the land claims, I mean, I had to give you the vision of these things from 40,000 feet. There are a lot of differences between them. and the Aboriginal nations that go to the table to negotiate these things are always trying to ratchet them forward and get more. So the board that I represent, the Wekiji Renewable Resources Board, actually has a final decision making on total allowable harvests. It's the only one that I'm aware of in the 3 territories that does. And so what you see in the claims themselves, I've often kind of called it's a tanglefoot process, in the sense that the co-management tribunal, they run like administrative tribunals. They're subject to the administrative law requirements for fairness. They do tend to be open processes, and when the time comes that the recommendation goes forward to government, particularly in the wildlife management context, where the boards, the Nunavut Wildlife Management Board is 9, and 8 of them are Inuit land claim beneficiaries. So it goes forward to the government, and if the government disagrees, they say, well, you have to give us reasons for your refusal, and you have to send it back to us. You have to give the board the opportunity to reconsider, and then we send it back to you, at which point you can make a final decision. That final decision has to be made public. Well, that's what I mean by trying to tangle it all up, with process. At the end of the day, co-management truly is a compromise, and it is, as I said, a function of these are institutions of public government, and so ultimately that means a minister somewhere is going to make, in most instances, is going to make the final decision. That's the devil, I guess, that the First Nations that negotiated comprehensive claims live with. They don't make that many final decisions in some of these contexts, but I will say, after 25 years of working with and around co-management, I think that the outcomes are palpably different than they would be if those decisions were just being made by officials of government. And I do think that in most instances, ministers of government are very careful about situations where they want to refuse them, and so that's the system, and it is not Indigenous governance on their own behalf.
Rob or Bill, did you want to jump in on that one at all? I mean, I think there's a lot of what's in all 3 of the talks. There's a lot of emphasis on collaboration, but there in many instances, or at least some instances, will come a point where you need to understand who has the final say, and I think that's an unresolved issue right across the country, and UNDRIP certainly has things to say about that too. When does the velvet glove come off, and who has the iron fist, if you will? Maybe time for one last question, if there is one. Wait for a mic here.
For Bill, with respect to clear-cut logging, and as you're probably aware, there was fairly extensive cutting north of the reserve in 2016 and 2017 in an area that I believe was designated by the Alberta government previously as critical grizzly bear habitat. Do you have an opinion on how operating ground rules for logging or the Forestry Act itself might be amended or changed to better accommodate grizzly bears?
We've been at odds with Alberta Forestry for some time, number of different ministries. We think that especially the forestry companies, we believe that they create the biggest impact on landscapes, impacting trees and habitat, and as well as waters and aquifers and springs, and that is creating a ripple effect. And that ripple effect is, I think, what we're seeing in terms of more wildlife coming into foothills and plains regions. And I don't think that that's being completely understood in terms of cumulative effects. So we continue to work with different ministries, forestry, transportation, environment and parks, and just hopeful that some consideration will be given towards things like the grizzly study, so that before we go charging out to these areas and developing areas, we have a good understanding of what these areas mean, not only on the scientific side, but on the traditional knowledge side. When the SSRP first came out with the final plan in 2014, our first recommendation was that we wanted to do cultural monitoring on Crown lands, all within SSRP. We should have that understanding before we have large-scale industrial developments. And so that is, we're getting some leeway right now with projects further south in being able to do cultural monitoring in select areas, but there's still a lot of areas and a lot of ranges that we have not looked at. We have not undertaken a formal study, and therefore we don't have all of that information, and we don't have that information, we may be creating impacts that with unintended consequences.
Thank you.
Great. Well, please join me in thanking this wonderful panel.